And so I have no choice in this matter
Please,
to set
please.
bail outside the defendant's ability to make it. It'll be set at $200,000, no
Oh my
contact.
God.
A woman appears in court to defend the man accused of assaulting her, telling the judge he's a great guy and begging the court not to keep him in jail. But when the judge reviews the defendant's long criminal history, the hearing takes a turn she clearly wasn't expecting.
Thank you, Your Honor. For this defendant, the state's seeking $100,000 with no 10% cash alternative. We're asking for DAS supervision along with a no contact order with the victim. We are also asking for no firearms or weapons, as well as house arrest and GPS prior to release. That is based on several factors. Number one, the underlying violence outlined in the probable cause declaration. In addition to the defendant's very high MPRA score of 13, you can see he got the maximum number of points for prior violent criminal convictions. He was paroled from his last felony in March of 2024. That was a DUI third out of our second judicial district court. When I pulled the pre-sentence investigation from that case, showed him to have 2 felonies and 22 prior misdemeanor convictions. 2 of those misdemeanor convictions were from 2022. They are those prior domestic batteries that were discussed in the probable cause declaration. One was out of Sparks Justice Court, or it looks like they were both out of Sparks Justice Court. He had issues with being out on bail in that case. Looks like he was revoked no less than 3 times on those cases. In addition to that, he has a DUI, and it is this, I think, also mentioned in the probable cause, same victim as we see here. Yeah, the misdemeanor DUI in 2019. He was released on supervised bail. It was later revoked. He was given probation on that case. It was also later revoked in 2020. He has misdemeanors for trespassing and destruction of property that year, another DUI in 2017. He's got a felony conviction in 2014 for intent to utter a fictitious bill. He received diversion on that case originally. He was removed from diversion and sent to prison on that case. And then he's got another misdemeanor conviction for domestic battery in 2012. He has a assault conviction out of Reno Justice Court in 2011, along with possession of drug paraphernalia. And then finally, another assault conviction back in 2007. We were able to speak to the victim, who I believe is present here today. She said she is not seeking a no contact order, and that she is not in fear of the defendant. She said he's a great guy with a really good job and a good provider. She says he doesn't have any weapons. But unfortunately, I disagree with the victim. We are asking for a no contact order based on the safety of her and her children. This, as you can see from the probable cause declaration, the victim was somewhat hesitant to report what happened in the first place. We know one of the children came forward and reported to police that the defendant had struck the victim in the face, and that she had injuries as a result of that. So based on his criminal history, his compliance issues, and obviously the violence in this case, we do believe a higher bail is appropriate and are seeking that $100,000 with those conditions.
All right, thank you, defense.
Judge, that would be a de facto hold on Mr. Johnson. We're seeking for an OR release in this case, maybe $5,000 bondable. This is one of the rather strange PC in that it seems that there was a fight earlier in the night in which other women jumped the victim in this case. And there was an argument between Mr. Johnson, and this is all in the PC sheet, and her about what had happened and whether or not he had let it happen or seen it happen. And the officer notes that the victim is actually striking him in the face when the officer sees her. He actually witnesses that event. I understand that the children may have seen something or may have seen her after or heard something. I'm not clear about that yet. This really looks like a case that needs to kind of go to trial and get figured out. But in the meantime, I don't think Mr. Johnson should be held in jail while we figure out what actually took place in this case. I understand the state can proceed on charges without her wishes or beyond her wishes, or against her wishes, that is. But given that he's been here for 19 years, he's got a job, he's got kids in the area, we're asking for an OR here or $5,000 bondable. He's not a threat to run. Although he has a history of violence, he does not have a history of taking care of business. He does show up to court and he will do as directed. We're not opposing any of the conditions as set by the court or as requested by Ms. Casso, Chief Casso, excuse me.
All right, let's go ahead and hear from the victim. Just go ahead and unmute yourself and you can let me know what your thoughts are.
Hello, can you hear me?
I can hear you. Go ahead. What would you like to say?
Hi, Your Honor. Good morning.
Good morning.
So this whole situation, it really is a real misunderstanding. I understand, like, I don't know, it kind of hurts me, like, they're bringing up his past and, like, looking at his past and stuff, but Deontay's been doing really, really good, like, very good. He's been staying out of trouble, staying out of way. He does have a really great job that he end up receiving. And if he doesn't get to work, like, we will even lose our home because we had just moved. He has never, ever put his hands on me at all. And with the whole situation that happened, it didn't even happen here in the house. And it had nothing to do with me and him. I locked him out. I was upset. You know what I mean? And I was more of like the aggressor. And, you know, we were bar hopping and things took place with somebody else. And I told them that. And I don't understand what is happening or why it's happening. And it does hurt because I know the truth and I know that that's not what happened. And he doesn't deserve it, to be honest. He's really great to me. He's really great to his children, my children. He's very enrolled, like, with the football, the travel team, just his kids. He's wonderful, and he's changed a lot, and he's trying to do the best that he can, and staying out of trouble. And we just happened to go out one day, and end up getting into a situation. Well, I did. So I just asked, I'm not scared. I'm not in fear. Neither are my kids. Everyone's just really upset. I was upset and I do apologize, you know, especially to Deontay. Like, I hate this for you and I just don't want to see him in trouble for something he did not do.
All right, thank you. Thank you for being here. I know this puts you in a very difficult position. I wasn't there. I don't know what happened. I'm in a position to take a sworn declaration from a peace officer who was there, whose job it is to investigate. And we don't, you know, blindly accept any statements made, but that's the evidence I have today, and it does support probable cause for this offense. The next decision I have to make is whether or not the state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. And I know it bothered you to hear the prosecutor go into detail about his prior criminal history, prior crimes of violence, prior failures, both on crimes of violence and driving under the influence charges with our courts. And you believe he's a different man than what that history portrays. But all the science says the best predictor of future behavior is past behavior. And so he will have an opportunity to make a new history for himself. And once these things get further away from him as far as years in his criminal history, then courts will not use it against him. But right now, these are the greatest predictors of what he's likely to do. And again, I know it's a different person than what you say you know. But I have to go with what the evidence suggests to me in this case. And so,
please don't do this. We're gonna lose everything. Like, I understand. I'm sorry. I'm not trying to talk over you, Your Honor, but I know, like, this is the thing, and this is the thing with the system, because I am myself a person that has a past, and I have changed my life around. I got my record sealed, He has changed. He's not who they're even saying he is. It's not. I promise you. He has an opportunity with a great job. He goes to work every day. And if he doesn't even go to work, he will lose his job. Then what? It kind of puts him in a situation. I don't want that for him. Or for us, we could lose our home. I'm begging you, and I swear, this is not what happened. It's not what happened. Please just take mercy and just at least a trial, okay, whatever we got to do. He will not run. You can't judge. Please don't judge. Give him a chance. Please.
So I believe in chances. I believe in second chances. I believe in third chances. And the hardest part of my job is either on the civil side, kicking people out of their home, or on the criminal side, putting someone in jail or keeping them in jail. Because I have done a lot of research, received a lot of education on the collateral consequences. I was just reading this weekend on best practices on these types of cases, and this very situation that often occurs where the victim is re-victimized by the financial hardship caused by incarcerating the breadwinner. And so while I've never been in your shoes, I have done everything I can to try and appreciate the situation that you're in and the consequences of my decisions. Luckily, the law says that incarceration is the last resort. And so it's consistent with what, my personal feelings are in this situation. But we use a scoring mechanism so that the judges are not, subjective. We're not going on our fears of, that objective tool indicates that the defendant has at best a 50 percentile of being successful.
More than that. More.
In this case. I know that's what you think, and that's great that he's got somebody supporting him, but that's not what the evidence says. And then I don't have any evidence that's been presented to me in this case or in all the years I've been doing these cases that shows that any of the conditions available to me will minimize that risk. And so I have no choice in this matter to set bail outside the defendant's ability to make it. It'll be set at $200,000. No contact.
Oh my God.
Separate criminal offense pursuant to NRS 178-4845, the maximum 120 days, firearms.
That is the problem with the system.
December 1st at 9 a.m. Bail laws may hold court appearances.
Yeah, what is the bail?
24 hours being released.
Loomis and then Madsen?
Upon being released, you have to make contact with DAS. Sign right here.
And sir, just so you know, DAS will be gone if you do post that bail by January 1st. So you'll be checking in with this court for your court dates. Thank you.